At the conclusion of this lecture, you will be able to understand the role and duties of company promoters, the breach of those duties, and remedies available to the company. You will understand the meaning of and the rules relating to pre-incorporation contracts. You will understand the procedure for registering companies, both public and private, and understand the statutory books, records, and returns that companies must keep or make. There is no general statutory definition of a promoter in company law. In Whaley Bridge Calico Printing Company versus Green, Bowen L. described the term promoter as a term not of law, but of business, usefully summing up in a single word a number of business operations familiar to the commercial world, by which a company is generally brought into existence. A person is not to be treated as a promoter of a company simply on the basis that they act in a professional capacity with respect to the establishment of a company. Thus, solicitors and accountants employed purely in their own professional capacity in order to establish a company will not be considered promoters. As with directors, promoters are in a fiduciary relationship with the company they are establishing. This is a position akin to that of a trustee, and the most important consequence that flows from it is that the promoter is not entitled to make a profit from establishing the company without full disclosure of that profit to either an independent board of directors or to the existing and prospective shareholders in the company. Such a situation usually arises in situations where the promoters sell assets to the company they are in the process of forming. Failure to make such a disclosure will enable the company to rescind the contract, claim damages, or hold the promoter liable to account for any profit made. The person or group of persons who take necessary steps to give birth to a company form of business organization are known as company promoters. Company promoters conceive an idea of starting a joint stock company and work on it to develop the idea and finally form the joint stock company. In other words, company promoters are those who discover the opportunities to make money, investigate such proposition, assemble and finance them, and thereby give a shape of a joint stock company. Company promoters give not only the birth to a joint stock company, but also nourish it till it stands on its own 2 feet. Functions of company promoters. Conceive an idea of forming a company. Analyze profitability of the idea. Investigate the workability of the idea by consulting experts. Decide the name and location of the company, and also the amount and form of its share capital. Prepare the Memorandum of Association, prospectus, and other necessary documents, and file them for incorporation. A pre-incorporation contract is a contract which promoters enter into, naming the company as a party prior to the date of the certificate incorporation and hence prior to its existence as a separate legal person. However, in law, the company cannot enter into a binding contract until it has come into existence through incorporation. The legal consequences of this situation are that the company, when formed, is not bound by the contract even if it has taken some benefit under the contract. The company cannot ratify or adopt the contract, even if it wishes to, after it has become incorporated. The person who purportedly contracted on behalf of a company in respect of a pre-incorporation contract is treated as if he had contracted on his own behalf. These consequences are a result of the ordinary rules of agency law, as stated in Kellner v. Baxter. And the third principle has been restated and confirmed in Section 51 of the Companies Act 2006. It can be seen from the wording of Section 51 that liability of the agent is contractual, but it should be noted that this liability arises whether the promoter contracts as an agent or not. Thus, in Phonogram Limited v. Lane, it was proposed to form a company, FM Limited, to run a pop group. Lane made a contract with Phonogram Limited for and on behalf of FM Limited. However, FM Limited was never actually incorporated. Consequently, the court held that Lane was personally liable for the money advanced to FM Limited by Phonogram Limited. The Court of Appeal held that the fact that Lane had signed for and on behalf of FM made no difference to his personal liability. To give effect to the words "subject to any agreement to the contrary" in Section 51, the words used would need to amount to an express exclusion of liability. Promoters can avoid liability for pre-incorporation contracts in a number of ways. For example, it is possible to avoid entering the contract until the company has actually been incorporated. The promoter may enter into an agreement subject to contract with the effect that there is no binding agreement until the company itself enters into one. As the promoters are usually the first directors of the company, they can assure that the company does not in fact enter into the pre-arranged contract. The promoters can expressly provide that they will bear no responsibility for any pre-incorporation contracts. Section 7 of the Companies Act 2006 sets out the method for forming a company, which is that one or more persons must subscribe their name to a Memorandum of Association and comply with the requirements of the provisions of the Act as to registration. Under Section 9, two documents must be delivered to the registrar: the Memorandum of Association and the application for registration. Memorandum of Association. It is not possible to amend or update a memorandum of a company formed under the Companies Act 2006. The memorandum evidences the intention of the subscribers to the memorandum to form a company and become members of that company on formation. In relation to a company limited by shares, the memorandum also provides evidence of the members' agreement to take at least one share each in the company. Under Section 28, provisions in the memorandums of existing companies will be treated as provisions in the articles if they are of a type that will not be in the memorandums of companies formed under the Companies Act of 2006. Articles of Association. The Articles of Association are the main element of a company's constitution, and in effect, they are the rules which govern a company's internal affairs. All the company's key internal rules on matters such as the appointment and dismissal of directors, the allocation of powers between the members of a company and its directors, will be set out in the articles. Companies are free to make such rules about their internal affairs as they think appropriate, subject to the provision that any such rules must not contain anything that is either contrary to the general law or the specific provisions of the Companies Act. The Articles of Association form a statutory contract between the company and its members, and between each of the members in their capacity as members. Section 18 requires all registered companies to have Articles of Association, and they have to be contained in a single document and must be divided into consecutively numbered paragraphs. Section 19 gives the Secretary of State the power to prescribe default model articles for the different types of company. Such model articles apply to companies where they have not registered any articles of their own or have not specifically excluded the operation of the model article in question. Model articles were provided for in the Company's Model Articles Regulations 2008. Under Section 9 of the Companies Act, the application for registration must contain the company's proposed name, whether the company's registered office is to be situated in England and Wales, or in Scotland or in Northern Ireland, a statement of the intended address of the company's registered office, whether the liability of the company's members is to be limited, and if so, whether it is to be limited by shares or by guarantee, whether the company is to be private or a public company, a copy of any proposed articles to the extent that the company does not intend to use the model articles. This issue will be dealt with in more detail below. Memorandum of Association. The application must also contain the following additional documents: a statement of capital and initial shareholdings or a statement of guarantee under Sections 10 and 11, a statement of the company's proposed officers under Section 12, a statement of compliance under Section 13, and a registration fee. Statement of capital and initial shareholdings. This document is required where the company is to have a share capital. Alternatively, a statement of guarantee is required where that is not the case. A statement of the company's proposed officers. Section 12 explains that this requirement relates to any person or persons who are to be the first director or directors of the company, the person or persons who are to be the first secretary. A statement of compliance. This requirement relates to determining whether the rules regarding registration have been followed, as set out in Section 13. Such a statement does not need to be witnessed and may be made in either paper or electronic form. Section 12 makes it a criminal offence to make a false statement of compliance, as is the case in relation to all documents delivered to or statements made to the registrar. The appropriate fee must accompany the documents, and once the registrar is satisfied that the requirements of the Act have been met, he shall issue a certificate that the company is duly incorporated. Under the Companies Act Section 394, a company's directors must prepare accounts for each accounting reference period, usually 12 months. These accounts must include a balance sheet and a profit and loss account and must show a true and fair view of the company's state of affairs. Accounting records must be kept for a period of 3 years for private companies and 6 years for public companies. In conclusion, there is no legal definition of company promoters. Promoters are involved in the creation of a company. The Memorandum and Articles of Association are key documents required for incorporation. Certificate of incorporation is issued after the registrar is satisfied all documents are in order.